This is a podcast for fundamentals of restructuring, insolvency and turnaround on the topic of the context of restructuring, insolvency and turnaround. What we're going to be covering in this podcast is an overview of different types of both personal and corporate insolvency appointments, and I'm going to take you through the different stages of common insolvency appointments, which I've called the 5 phases of insolvency appointments. We'll also take a brief look at some recent trends in insolvency statistics, and we'll talk a little bit about law reform. Moving now to slide 2. Let's move on to an overview of insolvency appointments. Okay, so what are the different appointments that can arise in personal insolvency under the Bankruptcy Act? So we'll start with the main appointment, and that's formal bankruptcy, and that results in the appointment of a trustee in bankruptcy. Now, the trustee can either be the official trustee or can be a private registered trustee. And the process for appointing trustees in bankruptcy and indeed making a debtor bankrupt will be discussed in next semester's subject, which is advanced insolvency. This subject's focused more on corporate insolvency, but it is useful to note that there are different types of personal bankruptcy. So voluntary bankruptcy, involuntary bankruptcy, which is creditor initiated, and then the possibility of a trustee taking control of property prior to formal bankruptcy under Section 50 of the Bankruptcy Act. So we'll talk more about how those appointments are affected in the next subject. Then there are alternatives to formal bankruptcy. So we can have the appointment of an administrator of a debt agreement, and that's under Part 9 of the Bankruptcy Act. We can also have what's called a personal insolvency agreement, which involves the appointment of a controlling trustee. Now really, the distinction between Part 9 and Part 10 on the one hand and bankruptcy on the other is that bankruptcy is a formal insolvency process, and an external administrator basically takes over the running of the debtor's estate, and actually goes further than that. The property of the debtor, with some limited exceptions, is actually vested in the bankruptcy trustee. And there's the status of being an undischarged bankrupt, which has quite a lot of civil consequences. So we contrast that with alternatives to bankruptcy, namely debt agreements and personal insolvency agreements. So therefore, you're not a bankrupt or an undischarged bankrupt under the Bankruptcy Act. So this idea of having a formal process with the appointment of an external administrator who takes control of the assets and having this formal status, you are bankrupt, and then the alternatives to that. Moving on to slide 3. We'll see there are some similarities there with corporate insolvency law. So the corporate insolvency law equivalent to bankruptcy is liquidation, and we see the appointment of a registered liquidator. There are different ways to get into liquidation. Namely, there is compulsory liquidation, which is by court order, and that can be on the grounds that the company is insolvent or on some other grounds, such as minority oppression, or simply because it's just inequitable. There's also voluntary liquidation or voluntary winding up, and we have both a solvent form and an insolvent form, namely members' voluntary winding up and creditors' voluntary winding up. And there are different ways to get into a creditor's voluntary winding up, and we'll talk more about those later in the course, and also in the next course, advanced insolvency. So, just as with personal bankruptcy, where we had formal bankruptcy and then alternatives to bankruptcy, we see the same thing in corporate insolvency law. So we have formal insolvency, external administration, which is liquidation, and then we have alternatives to liquidation. So the main alternatives are voluntary administration, a creditor's scheme of arrangement, and then we have a further alternative, which is receivership. But receivership really is quite different. Receivership involves typically someone who's privately appointed, who's working there in the best interests of the appointing secured creditor. So it's really quite a different process. But nonetheless, it's an alternative to liquidation. One of the features of corporate insolvency, though, is that we can have overlapping appointments. So you can have a company which is in liquidation as well as being in voluntary administration, as well as being in receivership. Similarly, you can have a company which is in liquidation and a creditor's scheme of arrangement. So you can have overlapping appointments. And again, we'll talk more about that as we go through the course. Moving on to slide 4. So we have a sense of what the different types of insolvency appointments are, both in bankruptcy with the trustee and in corporate insolvency with the concept of a registered company liquidator. And you have to be a registered company liquidator in order to accept an appointment as an administrator or to accept an appointment as a receiver. So having a sense of what the different types of appointments are, let's then think about insolvency according to common phases. So one of the things about insolvency law is that it's highly process-driven. Not many of the concepts involved in corporate insolvency law are very difficult to understand. The difficulty in applying corporate insolvency law is that there are so many rules. It's very rules-driven. It's very process-driven. And certainly the Insolvency Law Reform Act is doing nothing to change that. So I think it's helpful if we try and conceptualise insolvency law as involving 5 distinct phases. We can see those phases here on slide 4. Pre-appointment phase, the appointment phase, investigation phase, the reporting to creditors, dividends and priority payments phase, and the termination and transition phase. Now, of course, these aren't formal phases recognised under the Corporations Act or under the Bankruptcy Act. But rather what I'm trying to do here is to get you to see a range of issues that tend to occur at a particular point in time in the process of an insolvency appointment. And the benefit of looking at insolvency law that way is that it helps you to then narrow down the scope of issues and narrow down the potential range of statutory provisions that you need to look at. So the corporate insolvency provisions in the Corporations Act in Chapter 5 take up literally hundreds of pages. There are hundreds of sections. And so one of the things we can do to try and narrow that down, of course, is to say, well, what type of appointment is it? Well, even once we narrow that down, if we say, okay, it's a liquidation appointment. Okay, well, what type of liquidation appointment? It's a compulsory liquidation appointment by the court on the grounds that the company is insolvent. Okay, then what we can start to do is build a process line. Well, what's going to happen in this compulsory liquidation on the basis that the company is insolvent? What are the distinct phases of that appointment? And that will then help us to find the relevant rule in the Corporations Act and indeed apply the relevant rule. Okay, so let's have a look at what these 5 phases of insolvency involve. Moving on to slide 5. So if we start with the pre-appointment phase, what's happening in this pre-appointment phase? One of the things that insolvency practitioners are doing with their advisors is looking at the debtor's financial position, looking at their range of debts, looking at their assets, looking at their future cash flow projections, looking at their capacity to service their current and future debt obligations, and trying to work out some options. What can the debtor do? And so at one level, what we're doing is we're comparing informal workouts with formal appointments under external administration. So that's one of the things that occurs before the appointment. And indeed, one of the themes that we're going to talk about in this course is the detrimental effect of a formal appointment and how businesses and advisors try and steer debtors away from formal appointments in many cases. So what sort of work is an insolvency practitioner doing in the pre-appointment period? So one of the most common forms of work is, of course, the investigating accountant's report. Insolvency practitioners also get involved in forensic analysis, giving expert evidence, giving general restructuring advice, acting as a debtor's advocate or a debtor's advisor, particularly in disputes with major creditors, such as a tax office or a bank, and undertaking pre-lending reviews. So some of this work is initiated from the creditor side in terms of major lenders such as banks, requiring the appointment of investigating accountant or requiring a pre-lending review. And other times it's debtor initiated, where a company is looking at restructuring or is trying to assess its options. The other key issue that we need to think about in terms of pre-appointment is really working out, well, what is the company's financial position at a particular point in time, and then what transactions were occurring at that time and after that time. So we'll come back to this when we look at the powers of liquidators, which we'll be doing in the week 4 topic for this subject, when we look at powers of investigation and voidable transactions. And we'll also talk about it when we look at voluntary administrator reports to creditors, also known as Section 439A reports. And of course, the issue that's been in the press quite a lot over the last year or so has been that of the introduction of the safe harbour rule for company directors. This is a huge change in corporate insolvency law, and it's a change that's been a long time coming, and it's going to be very interesting to see how insolvency practitioners and other ARITA members operate within the safe harbour period. We've already seen a number of companies publicly announce that they're entering safe harbour restructuring negotiations, and of course there'll no doubt be a lot going on confidentially behind closed doors. So that's something insolvency practitioners are no doubt involved in. All right, so that's the pre-appointment phase. So are we looking at there was a formal appointment and there were things happening before that formal appointment? Let's assess what was happening at that time. What do we know about the company, its solvency position, and what sort of transactions were being undertaken? Moving on to slide 6 and the appointment phase. So what we're really doing here is we're working out, well, what type of appointment is it? And then how can we implement that appointment? So what are the steps that we need to follow in order to ensure that a liquidator is appointed properly by the court, or that an administrator is appointed properly by the company's directors, or that a receiver is properly appointed by a secured creditor? So how is the appointment to be made? And largely the rules are set out in the Corporations Act. So we need to work out who can appoint and how can they appoint. Then we need to be focused on, well, what do we have to do to accept the appointment? There has been a valid appointment. How do we accept it? What sort of notices do we need to give? When do we need to complete the DIRI, which relates to relevant interests and relevant past relationships and ongoing relationships? And we'll talk a lot more about that as we go through the course, particularly when we get into voluntary administration. We need to look at how we communicate with stakeholders, and that's something we're going to spend quite a lot of time on, particularly applying some of the guidelines in the ARITA Code. Of course, we need to take control of the assets. It is external administration after all. So the external administrator is taking control of some or all of the company or debtor's assets. So it's identifying those assets, locating those assets, and securing those assets, actually taking control of them, insuring those assets. In some cases, we need to work out whether or not we're going to trade on a business. So that, of course, will involve a whole range of commercial factors, assessing risk factors, what potential liabilities might arise, what are some of the potential economic outcomes, and we're going to talk a little bit more about the trading on decision and developing things like future cash flow forecasts to help make that decision in a couple of weeks. And then for certain types of appointments, particularly for voluntary administration, we need to be planning and organising the first creditors meeting, which has to occur within 8 business days of the appointment. Okay, so that appointment phase. Who can be appointed? How do we appoint them? Who can appoint them? And then what are some of the things that they do the first day, the first couple of days? Moving on to slide 7. So the investigation phase. So we've been appointed, we've done all of those initial actions, now we're getting down to the business of this type of external administration. So really this is focused on the role, the powers, the responsibilities of the external administrator. It's also focused on how the exercise of those powers affects different stakeholders. So we need to have a good understanding of how the appointment of an external administrator, whether it be a receiver, whether it be a voluntary administrator, liquidator, scheme administrator, deed administrator, we need to appreciate how that appointment is going to affect different stakeholders. So the company, the directors, employees, secured creditors, PPSA secured creditors, PPSA secured creditors with potentially unperfected security interests, general suppliers, general creditors, the tax office, etc. So we need to have a good appreciation of who are the different stakeholders in insolvency, in this particular insolvency, and then how is the appointment going to affect them. Now, as insolvency practitioners, typically we're going to need a range of advice on this. So we're going to need to consult with our lawyers, we're going to need to review key contracts, we're going to need to critically assess some of the major relationships that the debtor has in place with their stakeholders. And really this is building us up to how do we communicate with stakeholders, how do we keep them properly informed. So it's moving beyond just mere statutory reporting obligations to ASIC. It's moving on to how we engage with stakeholders on an ongoing basis. And indeed, the ARITA Code provides quite a lot of guidance on that, which we'll explore later in the course. And this process really is about deciding what to do with the assets. So can we sell them? In some cases, can we disclaim them? Can we sell the business as a going concern? Obviously, it's a mix of commercial issues, economic issues, and legal issues about what we can do, what's going to be best for the creditors as a whole, depending on the type of appointment. With a receivership, we're going to be focused more on preserving the secured collateral and realising that collateral for the benefit of the appointing creditor. One of the tasks that liquidators in particular will need to do is determine whether to pursue litigation. So in undertaking investigations, they might find that perhaps the directors have breached their duties to the company, or maybe there are some contractual rights that the company can enforce, and so they've then got to make a commercial decision about whether to pursue litigation. Of course, there are reporting obligations, both early on and then in some insolvency situations also on an ongoing basis, or again with voluntary administration towards the end when we're looking at reporting to creditors. Of course, we're going to need to examine the books and records. In some cases, they might need to be reconstructed. Obviously, that takes time, it takes money, it takes resources, and that will then help us to properly identify who the creditors are. Now, in some insolvency appointments, particularly administration and liquidation, we might be putting out proofs of debt. So calling for proofs of debt, who are the people who say they are creditors, and then what evidence have they got to support that. We'll be relying on things like the report as to the affairs of the company compiled by the company's directors. We'll be interviewing employees, we'll be talking to suppliers, banks, accountants, a whole range of stakeholders to build up a picture of what exactly is the financial position of this company. And in certain types of appointments, we'll be preparing for creditor meetings. In some cases, we might also need to go off and get our remuneration approved. Moving on to slide 8. So we've undertaken the investigations, we've worked out what's going on. Now we need to report to creditors. If there is a pool of funds available based on asset realisations, then we need to work out, well, how are we going to distribute that fund? This is corporate insolvency, so typically, and personal insolvency, so typically there is an insufficient amount to pay all of the debts that we've identified. So the statute, both the Bankruptcy Act and the Corporations Act, imposes a priority waterfall that we have to apply. And we can get into some quite tricky issues there that we'll discuss as we go through the course. Moving on to slide 9. So we've then undertaken our investigations, filed all the reports, sold the assets or sold the business, generated a pool of funds. We've paid back creditors as best we can, applying the statutory priority rules, and now we're in a position where how do we cause this appointment to come to an end? And of course that will be different depending on the type of appointment. We will typically need to lodge some final accounts and some final reports with the creditors and with ASIC, and in some cases we might be looking to transition to another form of appointment. So if we're in a voluntary administration, then that involves moving towards either a creditor's voluntary liquidation or to a deed of company arrangement. In some cases, we might be, for example, in a liquidation and moving into a voluntary administration. Or if we're in liquidation and we're not moving into another form of appointment, then that can involve going through the deregistration process. Now, of course, there can still be situations where there are concurrent appointments still on foot. So we can have a voluntary administration that transitions into a deed of company arrangement or transitions into a creditor's voluntary liquidation, and we still have a receivership which is on foot. Okay, so that's the 5 phases of insolvency law, and that's designed to help you just try and narrow down the scope of statutory provisions that you might have to have a look at. Both the Bankruptcy Act and the Corporations Act are based largely on a chronological process. So I think it helps just to be aware of where you're at in that process of insolvency, from pre-appointment to appointment, investigation and effects, creditor meetings, selling assets, determining whether that funds can be distributed to creditors, payment priorities, and then moving into termination and transition. So now we're going to look at some recent insolvency statistics to get a sense of where insolvency is heading and where it's been over the last several years. Moving on to slide 10. So slide 10 provides us with a snapshot of corporate insolvency for the last financial year. And what you'll see there is that the most common category are creditors' voluntary liquidations. And when you look at the historical trends over the last 15 years, which is on the next slide, you'll see that that's been the case at least going back to 2007. Now, the numbers of court liquidations there, we've seen a little bit of a softening over the last 12 months. And again, if you look on the next slide, you'll see there's been a bit of fluctuation with court liquidations. Also, the numbers of voluntary administrations have crept up ever so slightly, so that they're now at about 15%. They were at about 11-12% over the last couple of years. And you'll see there the numbers of receivership appointments and non-receiver controller appointments at about 3% each. And that's actually gone down slightly over previous years. Now, I'll just note here that these are the numbers of companies that are formally entering into these particular procedures. So these numbers come from the Series 1 ASIC statistics, which are lower in overall terms than the total numbers of practitioners who are appointed, which comes from the Series 2 statistics. But the main point from that figure on slide 10 is that creditors' voluntary liquidation is the most common type of appointment for a company to enter in terms of external administration. Now, if we skip over to slide 11, you'll see there the Series 2 statistics from ASIC, and the Series 2 statistics record all of the individual appointments, not just the companies, and so the numbers are higher here. And we see the total numbers of appointments are creeping up to levels that we haven't seen for a few years. So we came down following the GFC down to about 12,500, and we're creeping up again towards the 14,000 numbers of appointments in the last financial year. The levels of creditors' voluntary liquidation remain relatively stable at about 6,000. You'll see the numbers of both voluntary administrations and receiverships and controllerships have gone down slightly over the last year. Now, if you move over to slide 12, what you'll see there is a time series of voluntary administration and DOCA appointments. And so we see the overall numbers of voluntary administrations are certainly down from 17 years ago in 2000, sitting at about 1,600 over the last few years, and about 400 VAs, so a little bit less than a third of voluntary administrations each year end up in a deed of company arrangement. Okay, moving on to slide 13, so a quick snapshot of personal insolvency. So here we see the total number of personal insolvents under the Bankruptcy Act each year. In the last financial year is about 29,000. That's down from a high of about 33,000 from a couple of years ago. The majority are formal bankruptcies, either based on a voluntary bankruptcy or an involuntary bankruptcy at 17,000. And we are seeing an ever-increasing amount of Part 9 debt agreements each year, which are now up to historic high levels of 13,500. If we look at slide 14, you'll see there the grey line certainly shows the dramatic increase in popularity of the debt agreement procedure in Part 9 and the eventual decline of formal bankruptcies. And so we're getting up to almost 50% for each, which I'm sure will reach in the next couple of years. Now, of course, the interesting thing in this space to look out for is the government's innovation reform, which talked about a minimum default period of 1 year for formal bankruptcies. And if we saw that introduced, I imagine that we would see quite a dramatic fall in Part 9s. And legislation to implement that change has been introduced but has not yet passed the Parliament. Okay, so that's just a quick snapshot of insolvency statistics for the last financial year and also over the last few years. And what we see overall is a decline in appointments both at the personal and corporate level. And that then feeds into the debate about the need and the value of restructuring and turnaround as opposed to formal appointments. So if we now turn to slide 15. Okay, so what we've been talking about so far is formal insolvency, external administration type appointments. We need to contrast that with the increasing focus, both in terms of the business community, the insolvency practitioner community, as well as within the regulatory space, and that is the increasing focus on turnaround, restructuring and rescue of debtors. Now, what do I mean by those terms? There's no generally accepted definition of any of them. So if you look at any turnaround management books, if you look at corporate restructuring books, if you look at corporate insolvency books, you'll find, no doubt, different definitions of each of those terms. I've seen books that say, well, actually, they all mean the same thing, and you can use them interchangeably. So let's not get too hung up on exactly what we mean by one versus another. What I'm doing there on the slide is just trying to give you a sense of these terms referring to somewhat similar processes but at slightly different timeframes. So one way of conceptualising this is if we go to the next slide, you'll see a graph there that I've taken from the ARITA discussion paper in 2014, a platform for recovery, which you can find on the ARITA website. And that's got a good discussion of where we're at in terms of the law, although it was published in 2014, and so it doesn't include some recent developments. But just that graph, I think, is a really good illustration of where these different processes fit in. So really, liquidation is the end of the road. The company's generally insolvent. The range of options is pretty minimal. So obviously, the higher the asset value, the greater the range of potential options, both for the debtor and their advisors, and ultimately in terms of the commercial outcomes for creditors and stakeholders. So you can see distinct phases there of restructuring, turnaround. CRO stands for Chief Restructuring Officer. Just going back to the previous slide, I've framed that in a slightly different way, and that is based on a number of turnaround management books that I've looked at. Turnaround, I think, really is focused on implementing strategies to change a particular trajectory of the business, which is trending downwards. So you're either trying to return it to profitability where it hasn't been profitable in recent times, or you're hoping at least to avoid severe financial distress or insolvency. So once we get into that more distressed space, I think that's really when we're looking at restructuring options. So two different types of restructuring that we might talk about. Financial restructuring, which is looking at both short and longer term balance sheet repair. So short term in terms of just stabilising the business, preserving cash, trying to free up enough funds to meet the essential payments. While you negotiate a longer-term workout strategy, and then longer-term balance sheet repairs, actually doing things that will provide sufficient funds for the company to continue its operations. So looking at things like debt for equity swaps. Now we can contrast that with operational restructuring, which is really looking at the business, how it works, how do we gain greater efficiencies, how do we drop loss-making lines, how do we close loss-making divisions, how do we refocus the business to provide better outcomes and more sustainable outcomes in the medium term. Now, all of that, you could say, is really about corporate rescue. It's about trying to save the business, either of the company or of the individual, and a recognition that may well provide better outcomes for society in terms of increased economic returns for creditors, increased or at least sustainable levels of business activity, preserving tax receipts, preserving jobs, preserving supply arrangements, etc. So there certainly has been over the last really 30 years, 40 years, a more concerted effort to try and avoid the damage that formal insolvency appointments can do to a debtor and to try and rescue that debtor from that poor outcome. Now, we can also include the term workout there. Workout is typically discussed in contrast to a formal insolvency appointment, and you might recall that was one of the things that I talked about in the pre-appointment phase. Now, we will be talking more about workout and workouts and restructuring towards the end of this course. And, of course, there is a whole subject that is on offer called Advanced Turnaround and Restructuring, which is offered in the second semester. So moving on to the slide after the turnaround graph. Really, why are we having this debate? Why are we seeing a contrast between formal insolvency appointments and turnaround restructuring? Certainly there's a number of trends that we can identify which have been with us for some time and are increasing. And there's no doubt that at both the corporate level and the personal level, we're seeing declining numbers of formal insolvency appointments. And particularly for larger firms, there are fewer larger jobs. So we haven't seen many HIHs, Allco Finances, Babcocks and Browns, Ansets, these levels of appointments, notwithstanding recent examples like Dick Smith and Arium. There does seem to be a push in Australia and elsewhere. Indeed, all of our major trading partners, most of the OECD, most of the large developed economies in the world are looking at trying to reform their laws to encourage greater turnaround and restructuring rather than relying on formal insolvency appointments where typically the options are pretty slim. And I think we're likely to see increased reform in this area, with Singapore recently enacting very significant restructuring reforms and the European Union introducing its draft recommendation on restructuring and turnaround. So we're likely to see far more countries entering into significant restructuring and turnaround law reforms in the near future. And this is recognising that there is a stigma attached with insolvency. Now, we can debate all we like about whether we should adopt something like US Chapter 11, but there's no doubt that in Australia there are various sectors of the community, both the social community and the business community, that perceive insolvency as being a fundamental failure, and indeed in many cases perceive it as being a moral failure. So there is a stigma to formal insolvency. So we're looking for an alternative to that. And it's also recognising the effect that often the value of businesses depends less on heavy fixed assets that are really tied to a particular company or a particular debtor, and rather businesses are focused more on services, on the value of contractual relationships. And of course the danger is that there can be, and there often is, a termination clause or a review clause in those contracts that if you go into formal insolvency, well, the other party to the contract can simply terminate it. So that's one of the risks, and indeed the government's innovation statement has recognised that. And legislation has passed through the Parliament to offer protection against ipso facto clauses, although that legislation is not due to commence until mid-2018. We're also seeing, particularly at the larger end of the market, we're seeing an increasing secondary debt market. So banks being more facilitative in terms of selling down their debt to debt traders. We're seeing deeper pools of debt trading compared to, say, 10 years ago or more. And this has also led, in larger jobs, has led to fragmentation of senior lending groups. So we're seeing more and more debt traders coming in, distressed debt players, special situation funds who are coming in and buying up traditional bank debt from syndicate members. So that, of course, poses challenges for the way that insolvency law works, the way that our restructuring mechanisms work, and we've seen that in a number of recent large-scale restructurings.
We're also seeing an increasing familiarity with overseas funds setting up shop in Australia. So they're becoming more comfortable with our regulatory framework, with the way that our rescue and restructuring mechanisms work. We're seeing these very large and very deep-pocketed overseas distressed debt and special situation funds which are setting up shop in Australia. So the restructuring landscape is changing, and indeed we're seeing techniques that are used in the US market, techniques that are used in the Asian market and the European market being introduced and used more commonly in Australia. And I think really that poses a challenge for our law. So there is an increasing focus on law reform, that we need to think carefully about how our law operates and whether or not our legal framework sufficiently facilitates efficient commercial outcomes.
Moving on now to the federal government's innovation statement reforms.
And there are 3 insolvency reforms which are mentioned in the innovation statement.
The first being a move to make bankruptcy a default 12-month period as opposed to the current 3-year period. Now, this has been introduced in a bill in the Parliament, but at the time of this recording, at the beginning of 2018, that bill had not yet passed through the Parliament. I should probably also add here that there have also been changes announced that the government would like to put through relating to debt agreements, but they also have not passed through the Parliament. The second major insolvency-related issue under the innovation statement, the safe harbour protection for directors against insolvent trading, was enacted in 2017 and became operational on 19 September 2017. So we have the safe harbour with us now after many years of toing and froing and a lot of public debate. And then thirdly, protection against ipso facto clauses in contracts. And these have passed through the Parliament, but again, at the time of recording this podcast, had not yet been proclaimed by legislation, and they must commence at the latest by mid-2018. Moving on to the final slide now.
There's quite a lot of detail there. I'm not going to go through all of those points.
In large part because the federal government announced in 2017 that it was basically rejecting these recommendations, particularly issues around small liquidations and pre-position sales and the like. But it's still a useful summary of where law reform could look to in the future. And I have put the Productivity Commission's report in the supplementary readings folder for this week, because there really is some great discussion in there about how corporate and personal insolvency work.
And also on the restructuring environment in Australia. So I have posted up a link to that report, and you can have a look at different aspects of that. So there's quite a lot there that we could be seeing in terms of future reform. I guess one of the things that sticks out there for the purposes of this course is the refocus of voluntary administration. So we see the finding there by the Productivity Commission based on dozens and dozens of submissions over several rounds of submissions. Of course, we also had further submissions to the Financial System Inquiry at the same time, further submissions to the Senate Inquiry the year before in relation to ASIC's supervision of insolvency. And what the Productivity Commission has found is that the current culture, incentives and legal framework around voluntary administration inhibits its effectiveness as a genuine restructuring mechanism. That's a pretty damning finding. Essentially, voluntary administration does not work as well as it should as a restructuring mechanism. That said, they have rejected calls to introduce a US Chapter 11 bankruptcy-style debtor in possession regime. But what they have recommended is that voluntary administration be refocused to be limited to viable businesses. I think that would be quite a significant change, a radical change, some might say, to the way voluntary administration works.
And of course, the federal government, in its response to the PC report, has rejected that recommendation. Okay, so that is an overview of some contextual issues relating to restructuring, insolvency and turnaround.